Let's go to 106, People versus Henderson. Counsel, you want any rebuttal time?
Yes, Judge. 2 minutes, please.
Go ahead.
David Abatoy for William Henderson. Mr. Henderson presents two reasons for this court to reverse the felony murder conviction. First, the prosecutor.
Why did he go in? What was the intent of the burglary?
The intent of the burglary was to commit a homicide, as Mr. Henderson said when he grabbed the knife out of the butcher block. I'm going to kill him.
So if that was the intent and then carried it out, ultimately, why doesn't it make sense? But why can't it be? Why can't the burglary be the predicate for the felony murder?
Well, there's two reasons. Those facts show us that there's two reasons.
I mean, that was the intent and then it was carried out.
Right. The first reason why that doesn't make out a valid crime is that essentially he committed the burglary to effectuate the homicide, not the opposite, which is what the statute requires. The statute requires him to do something to effectuate the killing to further the accomplishment of the underlying felony.
That's why you're arguing Cahill.
That's why we argue Cahill and Langston, the Second Circuit case, that I think kind of distills out that particular.
Yeah, but
Didn't Cahill specifically say we are not deciding whether or not the same analysis applies with respect to felony murder?
I think first off, in Cahill, the Cahill.
Neither the Cahill's a capital case?
It doesn't, and I can tell you why. But
What about Miller while you're answering all the questions?
Okay. Miller is just factually different here, and I think this court said that quite clearly in People versus Lucas, and it even said that when deciding Cahill, I think.
You got a tough argument there, though. You're trying to say that your precedents under Cahill, which is pretty rarefied and exclusive kind of situation, whereas Miller is a much more run-of-the-mill, if you will, ordinary kind of crime, particularly because of the penalty, the death penalty issue. So I think you have a tougher argument there. I think you have to be able to address Miller, I think, directly.
Here's why Miller doesn't apply, and here's why I think you have an even bigger problem on the felony murder side
And
than you
don't
did.
forget, I still want to know why you seem to think Cahill has answered this question, and I don't think it does.
Okay, and I think I can do both of these at the same time.
Very good, Carl. Go ahead, do that.
Good job. Good job.
The reason why Miller doesn't apply is because of the very reason that you explained in Lucas. And Lucas says the problem that we identified in Cahill is that this single intent is the issue that repeats itself. In Miller, you have two different intents and two different victims, which is why it makes sense to punish Mr. Miller more harshly than you would punish Mr. Henderson here. The crime elevates.
So if Mr. Miller had killed the victim that he initially assaulted, your position would be that that would not be the basis for a felony murder? It
would essentially be just what we have here and just what we had in Cahill. And to get back to Judge Rivera's question here, and to go back, I think, to what Judge Fahey said as well, I think the reason why Cahill just applies just as strongly here, and the reason why the capital murder context doesn't really matter, is because the same reason why you said, essentially in Cahill to limit it, that this is a capital case and we're limiting it to capital cases, applies under the felony murder statute, or the felony murder interpretation. Here's the reason. When you decided Cahill, you said the Eighth Amendment requires us to limit and narrow these classes of people who are eligible for capital murder, because we don't want to expand that. That's against the Eighth Amendment. But the same rule applies to statutory interpretation. In People v. Hedgeman, you said that we're not supposed to interpret statutes so that we expand criminal punishment beyond that which can be fairly assigned to somebody. And when I read that holding in Hedgeman, and I look back at cases I cited in my brief like Brown and Cassidy and Giesland that talk about crimes not being, an underlying crime not being, quote, meaningfully independent of the, essentially the aggravating factor that's trying to ratchet us up only from homicide up to
So
murder.
let me ask about that independence from a different angle, getting back to what you first said. So you said the intent is to commit a homicide, but that's not what the defendant said.
He said, I'm going to kill him.
I thought the defendant said I wanted to hurt him. I didn't mean to kill him. Did I miss something in the record?
No, you didn't, Judge.
So how is it I intended to kill when he's saying specifically I didn't mean to kill?
And does it matter that the jury didn't find intent to kill?
I think it doesn't matter that the jury didn't find intent to kill. I think the issue with regard to whether, if you want to accept that he, first off, if you want to accept that he only entered to assault, I think that gets us to a reversal on the issue of the charge down on the man too. Because if you're going to accept that as the fact that is the most favorable to the prosecutor, and I don't think it is, I think the fact most favorable to the prosecutor under the Bleakley analysis.
In simplest terms, why isn't the homicide in furtherance of the burglary?
Because he didn't, because the homicide was the object of the burglary. He did not commit the homicide to make the burglary happen. In fact, the burglary was what this Court refers to as essentially preliminary or preparatory.
After killing him, he left. It's not like he went and looked for these drugs and the money, right? He didn't
Right,
look
and we
for any
see-
of this. He ran out.
Right, and we see cases
To go
just
as
like
quickly
that.
as he could to try and make it on the highway.
Right, and and that's how we know it's a single intent type case, like Cahill and like Lucas distills out of all this. We have cases where there are two intents, like Miller, and that's what makes it different. We have a Fourth Department case, Cooser, that also is we go in to kill one person and we kill another person. Those are the kinds of separate intents that I think Lucas contemplated when it discussed Cahill, and those are the kind of separate intents that we like to see when we essentially, in the penal law, ignore a mens rea.
So I say, I go in to kill him, I'm actually successful in doing so, that's not felony murder. That's homicide, that's a murder, but it's not felony murder.
It's some form of
The
homicide.
purpose, the goal, the aim is to kill the person I successfully killed.
Yes. And the reason why you should be just as concerned about this scenario as you were in Cahill about not expanding the class of people that are eligible for this is that felony murder is a good rule, but it allows us to essentially eliminate any kind of mens rea from the crime. And we elevate a normal, what might be in this case, just a manslaughter, to a much more serious crime on par with the most serious crime in the penal law without any kind of mens rea.
Now, how could this be a manslaughter? Explain to me that.
Well,
How do you get there?
The prosecutor presented evidence on his case in chief that Mr. Henderson said, I only meant to hurt him like he hurt me, which was a non-lethal force injury.
But there was a 5-inch blunt-tipped knife. There was a blunt-tipped knife that went 5 inches into his torso. That takes quite a bit of force, doesn't it?
Absolutely. But what is completely absent from the record, and what the jurors were entitled to credit, was the notion that Mr. Henderson was not the one that applied that force. I think it's clear, and Mr. Henderson admits, I went there to stab him. But it's also clear that Mr. Chambers falls and that there is no evidence whatsoever that Mr. Henderson was the cause of plunging that in that distance. He fell on the ground, which is where
So that's how it happened? You're saying there was evidence that the jury could have inferred from the evidence that that's how it plunged in that deeply? It was a fall?
The jury could have credited his testimony that he only intended to cause a superficial type injury, but that something much more serious resulted from it, which is the definition of recklessness.
Okay,
If you're I'm sorry, Judge.
Go ahead.
Just one quick question. If you're successful in reversing the felony murder count, he's still left with first-degree manslaughter, correct?
Yes.
So it's 25 is on the first-degree manslaughter, right, as opposed to 25 to life?
Yes, and we also asked for a new trial, though, on the charge-down issue, on that same subject.
On the charge down to second-degree manslaughter?
Yes.
I see.
Okay, thanks, counsel. Counsel?
Thank you, Your Honor. May it please the Court, Jason Carasone with the Warren County District Attorney's Office. The proof here is sufficient. That was the initial argument in point one, that there was insufficient proof and that the people had not provided sufficient proof that this murder was carried out in furtherance or in the course of and in furtherance of a burglary. And I think where this can get confusing is because burglary, unlike many of the enumerated statutes that we have, those ones that lift up felony murder, has a separate requirement that someone enter a building with the intent to commit a crime therein.
What was the crime?
I believe the crime in this case was some level of assault, Your Honor.
Wasn't that exactly what he did?
It was, yes, it was exactly
So
what
how
he
does that, why is that not a merger? As your opponent argues, in Miller, you know, he killed the other guy.
Right. And I think Miller basically, if you look at the way Miller's written, it indicates that there is a special place and protection that occurs. And merger, I would agree that merger would apply if you were talking about an assault that didn't occur inside of the residence.
If this happened out on the street, what happens?
If this happens out on the street, you don't have felony murder unless there was some other enumerated.
It just seems to me all you're saying is because he crossed the threshold with the same intent that he had if he crossed the curb, but because he crossed the threshold, that becomes felony murder as opposed to straight murder?
Yes, and it's because of the way the statute's written. The statute, and I think this case can be distinguished from Cahill. Cahill does have some restrictions on those enumerated felonies. They don't include all burglaries. It's burglary second, burglary first, among some of the others. And what I think makes burglary so unique is because to have a burglary, you have to have some underlying intent. It may be an intent to possess drugs, as he had in his first entry. It may be an intent to assault, as he claimed, the defendant.
But you're saying it's the same whether he's if he's on the sidewalk, it wouldn't be this, but because he crossed the threshold, it is.
Absolutely.
So so what do you say? There's a special intent. There's a special something. What's the special other than the place, right?
Of the enumerated felonies that are part of felony murder, most of them don't require the intent to commit a crime therein. That language doesn't exist. So when you look at a robbery, it's a robbery. There's not some other crime. With burglary, it's that unlawful entry with the intent to commit a crime therein. And the way it's written is any crime. It doesn't say any crime except assault, any crime except drug possession.
That's the fundamental philosophical concept underneath felony murder is the murder took place in the commission of another crime. But here, this is the only one, like you say, of a crime that requires trespass plus. It requires two crimes to complete the first crime. You see what I'm saying? To complete the burglary.
Well, I would disagree. I think it requires one crime, which it might. Well, you're right. The entry.
Yeah, there's that problem. You see what I'm saying? The other problem is you take it a step further. You can't have one intent for both the homicide and the burglary.
I think the entire felony murder statute, when we're talking about felony murder in the second degree, is based on one criminal intent that then it's a fiction that carries over to the felonious.
Why have it? In other words, you've got the guy for his homicide, and for some reason you want to say if he was going into the apartment to get his Sports Illustrated back, not felony murder, but because he's going in to do exactly what he said he's going to do, that's a felony murder and not just a murder.
Well, first of all, I think the appellant argues that his intent was to kill this guy, an intentional killing. This case, as was pointed out, went to a jury trial initially. He was acquitted of that. A jury of his peers said that wasn't his intent. He did not intend to kill. In fact, they found that the intent was to assault. So there are different intents. There's not just the intent.
Because of that, because I mean, you're saying, well, you really weren't that bad a guy. You know, you weren't going over to kill. You were going over just to beat him up. But because you were doing that, now you get felony murder and you're doing 25 anyway.
And I think the distinction is it's not that he went to beat him up. That's not the issue here. It's that he went inside a building with the intent to commit a crime. As Miller really lays out, the legislative purpose of felony murder is a protection. And it goes through and it explains there are significant.
That's what I mean. If he's going in to steal the guy's Pepsi out of the machine, apparently that's a felony murder. If he's going in to get his Sports Illustrated, it's not, because it's his magazine. That's not what this whole business is about. And to say that because he's going in to kill him, and we think, or the jury thought he wasn't going in to kill him, he's only going in to assault him, that raises the level. It seems like it's turning the law on its head.
I think it's following the law exactly as the legislature intended. If you look at the way it's written, it lists the enumerated felonies.
But you see Miller? I mean, doesn't Miller make a whole lot more sense?
I agree with Miller. Yes, I think Miller supports the verdict in this case. And
no, because Miller, you know, I'm coming to shoot you and I shoot him. So I get a felony murder on him. But that makes some felony murder sense. But if I'm coming to shoot you and I shoot you, I don't understand why that becomes a felony murder. It's just a plain old felony.
Okay. Well, if I could explain. When we looked at the Cahill case, it's been described, the courts described it as murder plus, and that's why there were two intents required. When you look at the felony murder statute in the second degree, as is applied here, the intent crime is burglary. What just makes burglary unique is that it has to have some other crime. And so, as the court's explaining, if his intent was to steal something and he killed and he caused the death, not intentionally, but caused the death of Duncan Chambers in this case, felony murder. But if he goes in with a little more anger and he wants to assault Duncan Chamber, and he causes his death, somehow that should get pulled out of this scenario. I recognize that the Miller facts are slightly different in that there were two individuals, but the Miller court indicated that when someone is in the confines of their home, there's a special protection that's afforded to them. And
Bottom line of your argument, legislative intent?
Yes.
The statute is clear, and that's the intent of the legislature.
The statute lays out.
Whether we, I think what we're all grappling around, trying to make sense out of it, but this has to do with the particular nature of burglary and why it's in there, right? That you have to go into someone's home. So if that's the intent, that's the intent, and it's different than if it happens on the street or wherever because of that built-in protection in your mind that the legislature intended.
In my mind and in the statutory scheme, it lists any form of burglary, including just a building. There's a special protection that's been created by the law, and it's listed these enumerated felonies.
From your perspective, that assault doesn't take it out of that statutory scheme.
Yes, and the reason is because the statutory scheme, which defines burglary, says any crime. I think the public thinks normally of a larceny. People go in to steal.
But is that a way to get around assault having been removed from the statutory scheme previously?
It's not.
Isn't that what you're doing, just getting around what was specifically a legislative choice to remove assault as one of the crimes?
No, and if I could explain. As we said, on the street, this assault on the street is not a felony murder case. It clearly cannot be because assault's been removed. It's the fact that a person went with intent to commit a crime therein.
I think on the street, if you say, well, he assaulted him and then he killed him, so it's a felony murder too.
You think that it is?
No, that's what I'm saying. At some point, when you go kill somebody, you're done, and you can't say, well, when you came in to kill him, that was one crime, and now even you had no intent to kill him, even though you buried a knife in his chest. It's felony murder, and we don't have to prove intent.
Well, the whole felony murder structure is that you don't have to prove that it was an intentional homicide. Correct. And whether it's you went in for a petty larceny and you're in the furtherance of that and you caused the death, or you went in to assault the individual and caused the death, it would be a change in the legislative structure if you were to modify that.
Could I just ask this question about in furtherance of going into the building? So what if Mr. Chambers had been killed in the hallway as opposed to in his own apartment? Would you still say it's felony murder?
If he was inside a building, right, and the entry was unlawful in that location, the way this particular apartment was, there was an outside and an inside. There wasn't a hallway in the structure of this particular building. But if he was in a place that he, meaning Henderson, lawfully could be, then you don't have the burglary, and then you would have a manslaughter, and you would have some other charges, which you would not have felony murder. You must have that enumerated felony, the burglary in this particular case.
Okay, thanks.
I'm sorry.
Judge Rivera.
We've still got a couple minutes left. Can you address the manslaughter in the second-degree lesser-included offense question?
Yes, and that's very much a fact-based analysis. And I think this court I want to make sure I've got my case right, is Rivera addressed this. And in the Rivera case, the facts weren't quite as compelling as they are here. In that case, there was actually the defendant made claims that he was just waving a knife around. He'd made claims and testified at trial about those events. In this case, the defendant very specifically voiced his intent. He gave a written statement to the investigator hours after his arrest where he admitted, I stabbed him. I only did it once. He also then testified at the initial trial, which was a part of the record of the second trial. And he said, as I think you had indicated, I'm not going to lie, I went in there to hurt him.
Well, could jury have found he didn't mean to hurt him that badly, and the victim fell, and that's how this deep puncture?
I would argue that that's not a reasonable view of the evidence. And the reason I say that is the medical examiner's testimony described that wound. And one of the things that was described, the court will recall, is the entry point and how it was the same width as the actual blade and how it was a clean entry. And it went all the way 5 inches through skin, through lung, and then through organs into the aorta. That's inconsistent with everything that we have in this particular case. And when making that determination on the charge down, there has to be a reasonable view of the evidence, and I submit that there wasn't.
Okay, counsel. Thank you.
Thank you.
Counselor Roboto.
Thank you, Judge. I'd like to address two issues that came up during my opponent's argument. First is the legislative intent issue that appears to be on the Court's mind. This Court has never had any difficulty dealing with something of the same problem that we have in this case, way back when the felony murder statute said that any crime could form the basis of a felony murder, including assault. And we have all kinds of cases going back to the Moran case, where Judge Cardozo said that we have to look at whether or not the substantive crime is essentially meaningfully independent of the true crime that is being charged here. And I suggest that you can deal with this in the same way that you dealt with those old cases, because the same problem that was left with that with the old merger problem remains in this one part of the burglary statute, or this one part of how burglary applies to felony murder.
But the difference is, and I think as counsel explained, that if you that the burglary presents an additional factor, an additional basis above and beyond the crime itself. In other words, it's a different crime. It may be the same intent used for both crimes, but it's not the same as if they were outside on the sidewalk.
Right.
Then there is no underlying crime at all. There's no burglary. There's just an assault.
The problem that the government faces in this case is this. The crime that's underlying the burglary is an assault. And the only thing that allows the government
But
to
if the legislature wanted to exclude that, they knew how to do that. Didn't they?
Perhaps.
That's what they did before. They intentionally changed the statute. And they said, we're not limiting the basis for the burglary. So,
of course, the legislature was also aware of this Court's continuous application of the merger doctrine, so I would suggest that that is known within the structure of the statute. The problem that presents
So it doesn't
itself,
address the question of in furtherance of what that language means.
No, that's essentially a different issue, I think, here that remains static throughout the penal law. This is kind of without regard to this double counting. But to get back to Judge Stein's point here, I think the real issue that should concern the Court is that without this assault, this burglary is just a misdemeanor. And the only thing that allows the government to get out of proving some sort of mens rea underlying this homicide is the notion that there is an imputed felonious intent to the homicide. Here, when you impute a felonious intent to the homicide, you impute an assault, which is excluded. So if you're going to pay attention to the legislative history and the legislative intent issue, I suggest that excluding assault is what you should be concerned about.
Thank you. Thank you both. Appreciate it.